Thank you so much for joining us today for our latest episode of Subro in Seconds, Butler's video blog covering up-to-the-moment case law and issues affecting the subrogation world. In recent years, the transportation and shipping industry has experienced significant growth. According to projections from the American Trucking Association, these trends should continue for the next 8 years. With the increase in transportation and freight needs, we can expect to see significant growth in shipping and cargo claims, which may present great subrogation opportunities. When evaluating damaged cargo claims, one of the most critical pieces of law that we need to look at is the Carmack Amendment, which was adopted to achieve uniformity with regard to interstate shipping. Under the Carmack Amendment, a carrier is generally strictly liable for any damages or loss to goods that occur during transit. The carrier is required to provide a shipper with what's known as a bill of lading, which is essentially a receipt for the goods shipped. That bill of lading may include critical terms such as limitations of liability and tariffs that may affect your subrogation claim. In order to establish a prima facie case under the Carmack Amendment, a plaintiff must establish, number one, that they delivered the goods to the carrier in an undamaged condition, and two, that the goods arrived in a damaged condition or didn't arrive at all. Then the burden shifts to the carrier to establish that it was not negligent in its shipping of the goods and that the damages occurred due to one of very few exceptions to the strict liability of the Carmack Amendment, which includes acts of God. Recently, the United States District Court in the Southern District of California analyzed a case to determine whether the Carmack Amendment applies to international shipments. That case pertained to a shipment of berries from Mexico to California. While in transit, the truck collided with a retention wall in Mexico and destroyed the cargo. After payment in the underlying first-party claim, the property insurers for the cargo asserted numerous claims against the carrier, including claims under the Carmack Amendment. The court noted that the statute provides jurisdictions over motor carrier liability between the United States and a foreign country, but only to the extent that transportation is in the United States. The court stated, had the damage occurred while the shipment was in the United States, the Carmack Amendment would apply. However, since in this case, the damage occurred entirely in Mexico, the Carmack Amendment was inapplicable. When evaluating damaged cargo claims, be sure to carefully evaluate all circumstances that may affect subrogation, such as the bill of lading and the exact location where the loss occurred. For more information on how to provide proper notice under the Carmack Amendment, please visit our website, www.butler.legal, and read the blog written by Scott Hefner in our Charlotte office titled, "Don't Wreck Your Carmack Claim." Please download the most recent episode of Subrosense, Butler's podcast dedicated to subrogation professionals. Also, please be sure to share this video blog from Butler's Twitter or LinkedIn account, and we will enter you to win this insulated water bottle with an integrated Bluetooth speaker so you can listen to Subrosense and Subro in Seconds on the go. Thanks again for joining us today. I'm your host, Aaron Jacobs. Until next time.